Ladies and gentlemen, this is a pretty unlikely thing to be doing on a Saturday morning in early December. To make it even more improbable, I would like to start with a reference to a non-Canadian and one who had little use for lawyers, at least for the rhetorical devices of lawyers. That's a man named Plato. On one reading of Plato's Phaedrus, there is perhaps an admonition to lawyers who engage in the giving of written opinions. Plato, through the voice of Socrates, seems to treat writing as a one-dimensional corruption of the fuller, more communicative act of speaking. Writing, or written words, he says, are a potential snare. Quotes, "You may think they speak as if they had intelligence, but if you question them, wishing to know about their sayings, they always say only one and the same thing." Well, it's part of the work of our profession to so craft words that on the page they avoid larger resonances associated with human speech, and in the words attributed to Socrates, they say only one and the same thing. Today's activities are meant to provide an examination of how we may best go about this difficult and sometimes dangerous business of giving legal opinions in the specific context of commercial transactions. We have it on the authority of the Oxford English Dictionary that it was common usage in 1888 that barristers in England advised on the law by giving what was referred to as an opinion on a case stated. Presumably, lawyers' opinions antedate 1888 by some decades, perhaps centuries. There is a line in Shakespeare, also quoted in my source, the Oxford English Dictionary, which, taken out of context, suggests that the Elizabethans knew the value of a sound legal opinion. The words are these: "I have bought golden opinions from all sorts of people." Well, we are regularly engaged in formulating opinions which we hope to make as golden as possible. This is a craft and a discipline, though not everyone sees it as such. I've heard the suggestion that lawyers form their opinions much the way Alabamians are said to weigh hogs. You know the method. First you find 5 hardy neighbors to help capture and bind the hog. That takes some time. Then you place the hog on one end of a barn board or barn slat, placed seesaw style on a large tree stump. Then you get the same group of neighbors to start gathering boulders, which they then place one by one on the other end of the slat. When the slat is finally in balance, they know that they're in business, and at that point, they start to guess the weight of the boulders. Well, if they were lawyers, I suppose they would instead render their legal opinion on the displacement effect of the swine. In an effort to keep both Plato and the hogs at a proper distance, we have the assistance today of a group of lawyers who are experienced in their fields and are prepared to step up and talk about giving opinions. I'm grateful to all of them for their help. Our first session this morning is intended to canvass some basic considerations about opinion giving. We're very fortunate to have with us Richard Lee of Temple University School of Law, Philadelphia, and also of the Baker and McKenzie firm in New York and various other places around the globe. Dick Lee has undertaken the special responsibility of advising on communication by lawyers in their writing, and he is a particularly appropriate spokesman for us on communication in legal opinions. Form and substance are intertwined in this area, and they come together in the consideration of the function of legal opinions. On this subject, Peter Jewett is well qualified to speak. He is a partner in the Torrey law firm. He has had ample opportunity to participate in the formulation of legal opinions in complicated commercial transactions. Peter also teaches, I think, at the U of T Law School, and somewhere along the line he manages to reflect on what's involved in the activity of giving opinions. Following their remarks, Dick and Peter will join a panel discussion with John Evans and Jack Geller to explore these matters further. John Evans is a partner in the Blake, Castles & Graydon law firm, and Jack Geller is a partner in the Campbell Godfrey firm. Despite their youthful appearance, they each have long experience with these matters. They're well armed with war stories and other ammunition for a lively discussion. Ladies and gentlemen, Dick Lee.
Thank you, Mr. Spence, and good morning to all of you. I'm impressed that this large number of people would get up this early on a nice day and come and listen to a series of speakers on legal opinions. I think it's appropriate that we start in talking about legal opinions with talking about how to write the legal opinion, because in the last analysis, our opinion is not going to do much good if it doesn't communicate what we intend in the opinion. I'm going to spend some time with you this morning working through some of the mechanics of that process of writing in hopes that out of it will come some useful suggestions for how to make those legal opinions effective as communication devices. Let me say at the outset that I am talking here about control in writing. I think it's important that we understand in all writing, but particularly in writing legal opinions, that we want to be very clear about what we want to say and very clear about what we don't want to say. Legal opinions of all kinds, whether they be first-party opinions to clients or third-party opinions that are going to be used by others, are a way of describing, on the part of the attorneys, a state of facts and a set of legal conclusions. It's critical, it seems to me, that these be as clear and as concise as possible. I have assumed, therefore, in my discussion today, that clarity is a goal. I concede that many lawyers, on many appropriate occasions, may wish to be less than clear. There may be times when the law is ambiguous and there is no way to be clear. There are other times, particularly in negotiating, when you don't wish to show your entire hand. But I think particularly in legal opinions, where we're addressing them to clients and to others, we have more of a chance to express ourselves in a very clear and concise manner. Now, I'm going to divide the material today into three parts. I'm going to talk about the style of writing, the structure of writing, and then finally the organization, and particularly the organization of a legal opinion. While there's no way that I can cover all of the material that is in the printed material that you have in front of you, I will make reference to it from time to time as we go through the examples. Let me start then with the style. And in order to talk about writing style, I've got to get us back quite a ways from the legal opinion and all the way back to simple sentences. You may say, well, that's very elementary. I didn't come here this morning to write simple sentences. And yet when you stop to think about it, it's a combination of those sentences that are going to make for the paragraphs and the paragraphs, the sections of the sections, the whole of the legal opinion. So I've really got to start at the beginning. There are some precepts that I think can be followed in dealing with writing clear sentences, which will make for a clear opinion. And I want to talk about those very, very briefly. First and foremost, in order to write a clear legal sentence, if at all possible, put the crucial action of the sentence in the verb, and then express the agent of that action as a subject to that verb. Look on page 3 for some illustrations. A typical lawyer sentence. We made a decision to have a discussion of the subject. What's the crucial action there? Something about decisions. A far clearer sentence is, we decided to discuss the subject. We've taken the action, decision, put it into the verb form, decided. We've taken the action, discussion, put that in the verb form of to discuss, and have made the sentence much more immediate and much more direct. The next illustration. There was a modification of the program by the state. Again, take modification, the crucial action of that sentence, put it in the verb form, and you end up, the state modified the program. Finally, further tests were conducted on the equipment by the engineers. The crucial action appears to be that of testing. Put that into the verb form, and the engineers tested the equipment further. What that process does is gives the reader the opportunity to see immediately upon reading what the action of the sentence is. It does something else. As soon as you have put the action of the sentence into the verb, you're forced to decide who is doing the action. English is delightful in its ability to throw away and throw completely outside of the sentence the actors of the sentence. By writing more directly, you're forced to identify those actors. Putting it another way, you give the reader directly who those actors are, rather than forcing the reader to imagine by inference where the actors might be. Now, that business about losing actors is very dramatically illustrated on page 5. One way we lose actors is by nominalizing. That's the only technical word I hope I'll use today, and it is the process by which we change action from the verb form and put it into the noun form or into adjective form. We decided that we should be cautious is a direct sentence. We can change that by nominalizing both of the verbs. Our decision was in favor of caution. Notice we've gotten rid of one we already. Then we can eliminate the decision part, our part, and put the decision was in favor of caution. There we've got a beautiful sentence that has no people in it. No one's home. And that may be useful on occasion when a lawyer is describing the activities of his client and he would like particularly for the client not to be in the sentence. But most of the time, we want to have someone in those sentences, and as a result, it's very useful that we not nominalize, at least not nominalize all of the time. The other way, of course, that we get rid of people in sentences is to change from the active to the passive verb. We signed the papers becomes the papers were signed. Now, the strict English would say by us, but of course we often leave the by us out, so we end up with a sentence that says the papers were signed. By us, by our clients, by the government, by whom? We don't know, in other words, from the sentence. Now, we can do that together. We can combine nominalization and passive voice until we have an absolute dilly of a sequence. Look on the top of page 6 for some illustrations. The most direct sentence is at the top. We believe you must prove that Jones was responsible before the court will resolve the issue in our favor. There we've got 4 actors, we, you, Jones, and court. All right, we start to nominalize. We believe there must be proof of Jones' responsibility by you for there to be a favorable resolution of the issue in the court. Already we're beginning to lose people. Now let's put it in the passive. It is believed by us that there must be proof of Jones' responsibility by you for there to be a favorable resolution of the issues by the court. Now let's just throw everybody out of the sentence. It is believed that there must be proof of responsibility for there to be a favorable resolution of the issue. A perfect sentence with nobody home. You, we, Jones, and the court have all disappeared from the sentence. Now, what that means to the reader is when the reader reads a sentence like 7D, the reader's got to say, it is believed. By whom? They've got to ask themselves that question. There must be proof. Proof to whom? Of responsibility. Whose responsibility? For there to be a favorable resolution. Who's doing the resolving? In other words, as you read that sentence, you have to ask yourself a series of questions. That's what makes that sentence harder to read, because the information isn't all there. It causes the reader extra time, and therefore it's slower to read as he or she tries to comprehend that sentence. You can make the reader's task far simpler by going back to a sentence like that in 7A. All right, that's the first principle. And I suspect I could stop there, because if you did that regularly with most of your sentences, not all, it would be a little boring, but most of your sentences in direct positive form, you would find that your writing would be substantially clearer than it would be if you continued to write sentences like the 7D sentence that I just illustrated. But I think I can give you some other rather positive suggestions. Once you've decided on having an actor in your sentence and having action in the verb and having then some object of that action in what in grammatical terms we called the object portion of the sentence, if you put those 3 crucial elements together rather than keeping them far apart, you have a sentence that is far easier to read. Look at 7A, and I won't read the whole sentence, but I will abstract it for you. The board's conclusion, then you've got a lot of stuff, and then at the last, is adequately supported in the record.
In other words, the person has to, once they get the board's conclusion, has to sort of hold their breath, waiting for conclusion to do what? Until they finally get the answer at the end of the sentence. Simply by moving that is adequately up to the beginning of the sentence would be far clearer. Now, there are more things that one can do with that sentence, and if we apply the two principles together, we end up with a sentence that is the B sentence. After considering the entire application, the board concluded that the relief requested by plaintiff would substantially impair the intent and purpose of the zone plan and zoning ordinance. This conclusion is adequately supported in the record. Simple, direct, straightforward, still expressing a complex idea, but expressing it in a way that is easier for the reader to understand. You'll note throughout my presentation, I'm referring to the reader, because after all, it is in the process of communication. What you're interested in is how well, how simply, how easily the person to whom you're directing your opinion is going to be able to absorb and assimilate that opinion. And if you start to think about that reader in your writing, you will find that you begin to make some of the changes that I'm suggesting here. Now, once we have those two principles, putting our action into the verb, putting the agent and action together in the core of the sentence, we still have some other stylistic changes to make. One of the most important is that you give your reader old expected information first, and then and only then proceed on to the new, the unexpected, the challenging. I'll put it another way. The beginning of the sentence is referred to linguistically as the topic portion of the sentence, the first several words up to the verb. The rest of the sentence is referred to linguistically as the stress portion. Why is it called the stress portion? Well, for several reasons. One, it seems that as you read, you tend to emphasize, even in speaking, the end of your sentence, the end of your line. Secondly, from a mnemonic point of view, you remember first that which you last heard. We could test this by giving you a whole sequence of sentences and then have you try to reproduce them. And it would turn out you would do best at reproducing the last sentence and less good at reproducing the second to last sentence, and the worst you would do would be with the first sentence. That's just the way in which the information is stored in the memory bank of our brain. I'm sorry to use computer terminology, but that seems to be the easiest analogies to use for making the point. If that's the case, and that seems to be the case in terms of all of the linguistic theory that's been done in this area, it makes sense that we put in that stress or important position in the sentence the most important information. But what is the most important information? The new information. So if we construct our sentences in such a way that the old and familiar is at the beginning, and the new and unexpected is at the end, we will have given the reader the information in a form that helps the reader to do the processing. Now, I've summarized all of that in a chart form on page 9, and I won't repeat it here, but just to alert you to the fact that that alone, that little sequence on page 9, would dramatically alter most people's writing. But there's more. We can take the style of the sentences and start working with them in terms of structure. In other words, we're now moving out of the sentence level and on into the paragraph. Here we're talking about something called topics. Now, the topic of the sentence is really what the sentence is all about. If you will, the subject of the sentence, but subject is usually a term that's reserved for grammatically what's before the verb. But the topic of the sentence is what the sentence is all about. If we organize our paragraphs in such a way that there is a relationship between the various topics in the sentences, we will have a paragraph that hangs together that is quite strong. There are several ways of doing that. One is to repeat at the beginning of each sentence the topic. And let me give you a good example of that on page 14, sentence number 5. And let me read that to you. Like a distributor, an agent is one who has been granted rights to trade in the principal's goods. The topic of that sentence, the agent. However, an agent does not act for himself in the release of goods. The topic of that sentence, agent. Instead, an agent is one who sells the goods for and on behalf of ABCO. Again, agent. Such an agent is usually paid a commission. When an agent makes a sale, the contract of sale is binding on the principal and the buyer of ABCO's goods. In each of those sentences, the topic was the same: agent, 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 agent. Now, I do recall that back in the 7th grade, the English teacher said, you've got to vary your sentences. And you should, once you've used the word agent, next time call it something else. That's fine for elegance in writing. That is not fine for clarity. I'm sure all of you have had to litigate or deal with statutes where the word was varied from the beginning of the statute to the end, and where there's endless discussion and litigation over whether or not your parliament meant that the words were the same or slightly different. In the law, when we're trying to be precise, we ought to repeat the words and use the same word throughout. That's a topic string in paragraph number 5, and is a very effective device for writing. It does one other thing. Once the reader sees the repetition as his or her eye goes through the sentences, it's much easier to keep moving. Oh yes, in the second sentence, we're talking about agents. Ah, I see we're talking about agents again in the third. In other words, there is a familiarity there, much like a repeated tune in a symphony, that gives you some assurance as you're going along that you're processing that information. In other words, you begin to skim, if you will, the first part of the sentence because it becomes old and familiar to you, and you can instead concentrate on the bits of new information that are being provided in the ends of each of those sentences. That makes it easier then to read that paragraph, and if it's easier to read that paragraph, it should be easier to comprehend it. Now, the other way of going is illustrated in the diagram on the bottom of 14, and then I'll show you a sentence like it, where what you do is chain topics. You take the end part of the first sentence and make that the topic of the second. You make the end part of the second sentence the topic of the third, and chain your way through a series of sentences. A very good illustration of that is on page 12, sentence 2b. Let me read it to you and point it out how the technique worked. At the outset, that sum may not appear to be particularly onerous. This, by the way, is an opinion letter where the attorney is trying to advise his client that, yes, there is a fine, but there also is a criminal sanction. And he's trying to emphasize the fact that while the fine isn't so much, the criminal sanction is something that his client might not be too happy about incurring. So at the outset, this sum may not appear to be particularly onerous. The next sentence picks up on the onerous. However, the troublesome provision, really a reference back to the onerousness, is not the $500 fine, but the 6 months in county jail. All right, jail is picked up then. Even though no jail sentences have been rendered against ABCO so far, the fact that the violations are criminal in nature causes serious concern. We then pick up the criminal in nature, the criminal aspects of these violations, etc., on to the end of the paragraph. So each sentence begins with a reference back to the point being made at the end, at the stress position of the preceding sentence. That knits, if you will, those sentences together and gives the reader a way of being propelled forward. And it makes the whole paragraph one that's capable of being read much more quickly. Those two techniques, the string technique and the chaining technique for topics, are the two best ways of constructing paragraphs and are the most effective from a linguistic point of view. Now, let me give you another example as to why that makes an awful lot of sense. Look on page 18 at a very long paragraph, and I won't ask you to read it all because it really is too long, but I have diagrammed it out by putting the topics of each of the sentences on the left-hand side of the page. We have the same page numbers, I hope, and the rest of the sentence on the right. Just go down the left-hand portion, and I'll read to you the various topics. The United States versus Aronoff, the SEC in that case, certain facts and documents which were not privileged, the court, the defendant's second lawyer, the defendant, the defendant's lawyers, the court, since it, the court, any further inquiry, these circumstances. A number of different topics. Now, turn to a rewrite on the next page, 19. We've taken and gone through this very same paragraph and organized the sentences so there's some consistency of the topics. Look at those. In a very recent case, in that case, the defendant's first lawyer, the court, the defendant's second lawyer, the defendant's lawyers, the court, the court, the court, the court. What we have in the second sequence is a series of topics, first of all, are far fewer. We've gone from 9 topics to 5. But more importantly, the 5 topics relate to each other in a familiar cast of characters. If you're talking about court opinions, who is the cast of characters? The defendant, the defendant's lawyers, the court, and the opinion. Those are the things you expect to be, if you will, the subjects of sentences talking about a court opinion. That's what we've reserved for the topic position of each of those sentences. So that in reading, we don't have anything unexpected or unusual at the beginning of each of those sentences, and instead, the material that's unusual and unexpected is reserved for the balance, the stress position of each of those sentences. That kind of organization of topics around a theme, again, makes the reader's task that much simpler. All right. Once we've done that, we then have to decide for sure that in that construction of sentences, we have a point. And we really have to say very simply, and this goes all the way back, I'm sure, to English lessons back in the grade schools, that every paragraph has to have a point. I should say every paragraph really has to have a point, or at least one coherent and coordinated set of points. If you ask yourself the question as you're writing, what is the point of this body of material? You will soon find that, one, you can design paragraphs that are consistent in terms of talking about one and only one point, and secondly, that your points begin to flow in a logic. If you will, you're beginning to outline your own writing. Now, once we decide that we have to have a point, we then do have an issue as to where to put it. And there is here 2 strategies. If we put the point at the beginning of our paragraph, we have helped the reader tremendously by announcing, if you will, this is what we're going to talk about. And that's very helpful to the reader. That means that everything else that's read is going to be read in the context of knowing what the point is. The disadvantage of that is that the reader, knowing what you're going to say, may decide to skip the rest of the paragraph. He already knows what the point is going to be. Why does he need all of the backup or the documentation of that point? I'll just skip on to the next paragraph. And indeed, if all paragraphs are so organized, I can soon discover that I can get through your document by reading the first sentence of every paragraph. Great from the reader's point of view, not necessarily great from yours if you want your audience to have read through. The way, of course, to get your reader to read your paragraph is to save the point to the end. He's got to read through it all because he doesn't know what the paragraph is about until he gets to the end and you finally make your point. That's great for getting the reader to read, but it makes the reading harder. And so if you do reserve your point for the end of the paragraph, you have to give the reader enough clues in the course of the paragraph to make it possible to get through to the point. So those are both good techniques, and it depends entirely on your strategy as to how you want to proceed. Now, once we've gotten that far, we can make the same kinds of generalizations about the opinion as a whole, and after all, that's what this is all about. If you can ask the very same questions about the point of the whole opinion that you can make about the point of the individual paragraph. That is to say, your opinion obviously has to have a point. That is to say, that's the conclusion, if you will, from your opinion. And that opinion, that point, has really 2 possible places where we can put it. We can put it right at the beginning and tell our client, yes, you can do this, no, you cannot. It is our opinion that it would be inadvisable to do such. I hope you don't write that way. Or you can save it all to the end. Again, the same kind of strategy. If you disclose it right at the beginning, there is the danger, or maybe there is the opportunity, and maybe that's a better way to put it, of the client not having to go through the rest of the discussion of the opinion letter. Now, that may be very valuable if what you're doing is sending something out, which is a bit of advice, and you're sending it to the chief operating officer, executive officer of the company, and you know it's going to be duplicated and sent on to all sorts of other people. It would be useful under those circumstances that you have everything up front. On the other hand, if whom you're writing to is the corporate counsel, it may be that you want the corporate counsel to have understood all of your reasoning before the point. If so, of course, you would save that for the summary or the end of the document and, in effect, force the reader through the document until he gets to the end. You've got to really sort of choose between the completeness theory, which is this putting it at the end, and the efficiency theory, which is putting it at the beginning. My own choice is not to choose. That is to say, is to do both. Put the point at the beginning, near the beginning of the document, and again at the end. And from a linguistic point of view, that makes a lot of sense, and that turns out to be the way in which most legal opinions are written. You start out with an issue, you start out with some summary of the material on which you are going to base your opinion. You then come up with a summary or conclusion of that opinion. There then is an elaborate discussion with regard to the opinion, and then finally at the end, there is some sort of a conclusion. Now, with that in mind, let me make a series of direct suggestions as to how to organize opinions. First of all, as I just indicated, make the point early. I think that's very important in terms of helping the reader to understand what is going on. Second, provide a table of contents. Now, you may balk at that and say, what? A table of contents in the middle of my beautiful opinion? That would disrupt it terribly. If you mean by table of contents literally something that looks like the table of contents in the front of a book or the front of a brief. If you balk at that notion, there are some simple ways of doing it in textual form, and I've given you two illustrations. Look at page 26, for example. The second paragraph, the bottom paragraph, is basically a table of contents. Part 1 of this memorandum consists of A, the draft charter, and B, the bylaws. Part 2 sets forth the procedures. Finally, Part 3 summarizes the principal laws affecting the contemplated investments. That gives the reader some understanding of the various parts of your opinion, how they relate to each other, and provides a very, very useful table of contents, if you will, for the opinion. Another way of doing that is on page 27, where, in effect, the argument is outlined in the first paragraph. I now believe the factors most strongly in favor of ABCO are 1, 2, and 3. The weaknesses in its position are 1, 2, and 3. These weaknesses are dealt with on such and such a pages, and the like. Again, in a textual way, outlining what it is that you're going to say in the opinion. Terribly, terribly useful. Beyond tables of contents, use what I call roadmaps. At every possible opportunity, tell your reader what is coming, where it's going to be located, and how to look for it. It seems to me that every section beyond a page needs a roadmap. If it's beyond 2 or 3 pages, it probably needs a very elaborate roadmap. Again, to help the reader to go through, to understand what's happening in the opinion. Provide headings and numbers. A terribly useful but rather simplistic device. There's nothing worse than looking at a whole page of text. If you're a reader, and I'm sure you've had the same experience, if you see a whole page of text, the instinct is to immediately turn the page. You just don't want to have to slug through it. And there are ways of dealing with that. One is to break it up. Headings and numbers for those paragraphs is a very useful way of keeping the reader propelled. Beyond that, if you leave a fair amount of white space, you make it easier for the reader to assimilate. You just look at a well laid out newspaper or magazine, and you'll discover that the pages that you tend to read are those where there is ample white space. That's a device that makes it more readable and therefore attracts you. And after all, if you're trying to get people to read your opinion, that's the whole reason you've slaved over it, then put it in a form that makes it readable. I guess it should go without saying that you should revise your draft. All too often, however, as lawyers faced with busy deadlines, we tend not to. That turns out to be often a disaster. It's usually a disaster because in the process of writing, we tend to revise our thoughts. We tend to come up with ideas that weren't there when we began the organization. If that's the case, we ought to then, once we have come up with a different set of thoughts, reorganize the opinion by moving blocks from one area to another. Revision is absolutely critical under those circumstances. Next, address the client's concerns. Too often, what you get in opinion letters is what I refer to as a journey through the library. First, I read these cases. Then I went to the statutes. I found the following information. From there, I advanced, etc. And you do it case by case by case. Well, that's fascinating to you. It's a little diary of how you worked over the last several days. It's not at all fascinating to your client. And the more you can avoid that kind of writing, the better off you will be and the happier your client will be. The client is rarely interested in your research, rarely interested in the way in which you went about your research. So you've got to address your client's questions. Too often the client says, "What should I do?" and the lawyer responds, "Here is the law." That simply isn't addressing what the client asked. And if you think about that as you're going, that's very important. And then my second to last is to consider the client. I've heard, and others who have looked at writing of lawyers, the complaint clients make most often is, lawyer writing is so cold and impersonal. I don't think they're real people over there in that law firm. Why? Because what they see in the writing doesn't suggest that there's a human writing or that there's a human being that it's intended as the reader. If you put some U's and I's in there, if you put the name of the client in the sentences, if you consider the way in which you write that you are trying to communicate directly with an individual, as you would in a face-to-face context, the client is going to say, "Oh yes, he really cares about me. He really is addressing himself to my concerns." My final rule, which I didn't think was going to be my final rule until I discovered it after I'd submitted this paper, is by all means proof your opinions. And I hope you all have the errata sheet which I submitted. I've put at the end of this document a series of appendices which I think will be of use to you. I've quoted, without benefit of permission, from several of what I consider to be some of the better writers in this area. And I hope you will justify my quotation without permission by going out and buying each of the books that I have quoted here. That will justify, I think, the quotation. And then finally, I've put in two sets of bibliographies, one that includes some British books, and then finally a plug for what I consider to be the best of the books on writing, which is not a book on legal writing at all, because I am firmly convinced there is no such thing as legal writing, and that is the book by Professor Williams on Style, 10 Lessons in Clarity and Grace. It is the appropriate successor. That's the very last document at the very end of the material. It is, in my book, the appropriate successor to the Strunk and White book on elements of style, and ought to be in every lawyer's library. Thank you again for the opportunity to speak with you today.
I'm sure you've all had the experience of trying to read statutes and being very confused by statutory provisions. If you take a moment sometime, this is particularly true of the statutes of Canada, and look at a long, typical section, you'll find that the verb very frequently is one of the last 15 or 20 words in a section that can go on for 100, 200, 300 words. And if you look at Dick's paper and the structure of sentences, you'll get a clue as to why it is so difficult to interpret a section like that. You often have gone through a whole series of thoughts before you get to the active part of the section. It really is quite intriguing. If you break down the structure of statutes, you find it's very different from the way people talk and the way people generally write. Before I go on to talk about the function of legal opinions, when I'm finished, we'll have a short panel discussion about it. If any of you have any questions about the things we've been talking about in the first panel, there are little question sheets in your materials. I would ask you to write out the question and hand them to any one of us, and we'll consider them. In a lot of ways, giving opinions is the function that characterizes a lawyer from other people in the business community. If you look at a legal matter, often what the client is looking for when a lawyer is retained is the legal opinion rather than the other functions that the lawyer carries on. For example, in a real estate transaction, a simple real estate transaction, the actual conveyancing of a title is something that many different people can do. And that certainly is one of the things the client wants. But the client also wants a title opinion, and that is the domain of the lawyer involved. On a corporate transaction, for example, a public offering of securities, one of the functions that the lawyer will get involved in is drafting a prospectus, but lots of people are capable of drafting prospectuses. The thing that a lawyer brings to the table that is unique is the ability to give the opinion at the end of the transaction that the securities have been properly issued by the company, properly authorized, and that the sale of the securities to the public has been qualified under the relevant laws. And yet, one often hears lawyers complaining about giving opinions, being reluctant to give opinions, trying to cut down the scope of the opinion as much as possible, presumably on the theory that somehow or other the lawyer's liability in the transaction is directly attached to the opinion, and the less that is said, or better still, if no opinion at all is given, there will not be any liability. We'll look during the next panel at liability and the grounds for liability on opinions. It seems to me that this view is really misguided. There may be situations where there are good reasons for not giving an opinion or trying to limit an opinion, but in general one shouldn't be afraid of them and shouldn't start with the idea of resisting giving an opinion. Opinions are very useful tools for focusing your work and have a very useful reporting function. In fact, it may be that giving an opinion, sitting down and setting out the scope of the opinion, the assumptions that were made, the qualifications to what is said, clarifying the instructions from your client, in fact, limits your liability rather than extending your liability. It has always seemed to me that there's some danger that if you hold yourself out as a competent lawyer and you're retained to handle a matter and you don't give an opinion at the end of the matter, that you will be held, in fact, to have been tacitly blessing the whole transaction and holding out to your client that everything has been done that should have been done and that the client has ended up in the position the client expected to be in. In many cases, that is not true. In many cases, the client may have specifically instructed you not to do certain things or specifically instructed you to make certain assumptions. If you don't get to the point of setting those out clearly in writing, you have nothing after the fact to demonstrate those instructions, nothing to demonstrate what qualifications you were making along the way. So in fact, not giving an opinion may involve more liability than giving one. It's similar perhaps to a car manufacturer giving you a 1-year warranty on the car and making a big hoopla about a 1-year warranty. Without the 1-year warranty, it's quite possible that the sale of goods laws would impose a 3 or 4-year warranty, a worthiness kind of test. Having said that, which is the lawyers, looking from a lawyer's point of view at the question whether an opinion should be rendered or not, if you look at it from the client's point of view, a client who has just heard what I've gone through may very well think, well, that's great, I'll actually discourage my counsel from giving an opinion if that in some sense is going to leave me with a broader blessing of the matter than getting something in writing. I'm not sure that when the client sits down and thinks through that is really an intelligent position to take. While there certainly is that general blessing aspect of it, the client should be more interested in having the transaction handled in an effective manner and ending up in the position the client wanted to be in rather than ending up with a cause of action against the lawyer. An opinion is a very useful method by which the client can check exactly what was done and what assumptions were made along the way. And stating it another way, it's a way of seeing what was not done and clarifying instructions. That whole process, the reporting process, is what I've described in my paper as the reporting function of opinions, which clearly is one very important function of opinions. Maybe I could take a moment and break down opinions into types of opinions. It seems to me that there are two very general categories of opinions. One which could be described as analysis opinions or analysis of the law opinions, and another category which I've described as transaction opinions. In the analysis of the law category, there are a number of different types of opinions, and we'll look at some of these this afternoon. One type is what I've called interpretation opinions, which would be an opinion interpreting a contract perhaps, interpreting a set of facts and applying the law to those facts, or interpreting a statute. One of the speakers this afternoon will talk about FIRA opinions, and a FIRA opinion is often a good example of an interpretation opinion. A second category of what I've called analysis opinions are advice opinions, which are related to interpretation opinions in that they take a set of facts, apply the law to the set of facts, and end up advising the client as to what the client should do or might do to stay within the law or deal with a particular matter. For example, if a client walks in and asks you, what internal mechanisms should I put in place with my sales force to keep myself on side under the competition acts? That would be presumably an advice opinion, which would end up with a series of steps that would be designed to avoid anti-competitive behavior. On the transaction side, you get opinions ranging from what I've called a report or a reporting letter to a full-blown formal opinion which sets out in a very formal way the steps the lawyer has taken, the assumptions that are made, the qualifications that apply to the opinions given, and then in a very formal way a series of paragraphs giving legal conclusions in a particular matter. Then there are clearly opinions that are a hybrid of those two things. If you look at a reporting letter, an opinion on a reasonably straightforward real estate transaction, you'll find sections of the letter which are a clear report of what was done. You know, we checked the outstanding hydro account and found so much was owing. We checked the outstanding gas bills. We checked the zoning bylaws and the property is zoned this way, that sort of thing. But there'll also be in the center of it a formal certification of title. Based on our searches of title, you have good and marketable title to the property. So that really combines the two aspects. The reporting part of it is as I've been saying, a key element of what can be done with an opinion. From the lawyer's point of view, setting out the assumptions and qualifications and setting out the steps that were taken are a method of clarifying for your client what you have taken responsibility for. From the client's point of view, it clarifies what the lawyer has done. And I would suggest that in really all matters, naturally if you are dealing with a matter that's very repetitive in your practice, some of these things will become unconscious. But in most matters, I would suggest that sometime before the thing is actually finished and the opinion or report is rendered, you should sit down with your client and go through what you are going to say in that report so that there's no confusion between you as to what you are responsible for. I often have some concern that when you send out a reporting type opinion that has some fairly significant limitations on the activities that you've undertaken, that the client may be very surprised to find that you have not done things that it was desired that you do. Another aspect of the use of opinions in your practice is what I've called the planning function. Continually you see, and I'm sure you've experienced this yourself, you see students or younger lawyers come into the office and be given a matter to work on, and the threshold question is, well, what do I do with this file? And even a reasonably straightforward transaction may involve 15 or 20 closing documents. Or if you get into a full-blown corporate financing, the lawyer sits down and sees the closing documents from a previous financing, and you know, it can be a book that thick with 80 documents in it, and you're left very confused as to what all those documents are. I have found that in instructing people to organize a transaction like that and figure out what steps have to be taken and how all those documents fit together, why they are sitting there on the closing table at the end of the day. A very useful way of going at that problem is to start by thinking about the opinion. If you sit down and decide, okay, what is it that my client, or in the case of a third-party opinion, what is it that the party on the other side wants me to say in the opinion? In a way, you're sort of working backwards through the thing to figure out what you should do to get into that position. In corporate opinions, you will find in almost every one that the opinion starts off by saying something like the XYZ company is duly incorporated and existing under the laws of such and such. If you think to yourself, now what do I need in order to give that opinion? You come to the conclusion that you need evidence that the company exists, pretty obviously. What evidence is that? The evidence is an existing charter of the company, articles of incorporation or articles of continuance or letters patent, whatever the case may be. So one of the things you're going to need at the closing is a certified copy of the charter documents. And you will naturally have to yourself or instruct somebody to go and get that copy of the charter documents. To make sure that it is existing today, you probably will want a certificate of status from the jurisdiction under which the company is incorporated. So that's another document you need, a certificate of status. So just that one paragraph has now produced, in addition to your opinion, 2 other closing documents and 2 other steps that you have to take to get those closing documents. An opinion on the validity of a contract that has been entered into by a corporation will usually involve you giving an opinion that the contract has been duly authorized by the corporation and has been duly executed and delivered. Well, what do you need to give that opinion? Well, first of all, you need the contract. Secondly, you need to know that the company exists, so you need the charter of the company. You've got to know what restrictions there are on the activities of the company. Those restrictions might be in the charter in part, and more likely in the bylaws of the company. You've got to know that the contract has actually been authorized by the managers of the company, so you need a board of directors resolution dealing with that particular contract. You have to verify that it has been executed by the people that are entitled to execute contracts for the company. To discover that, you look in the bylaws and perhaps in the director's resolution. And then you have to verify that the people that actually signed it were who they purported to be, and to do that you may look for a certificate of incumbency which sets out the officers of the company and their signatures so that you can compare the signatures. So to give what seems like a standard, straightforward opinion that a contract has been duly authorized, executed, and delivered, you need the contract, the charter, the bylaws, the director's resolution, a certificate of incumbency. That's 5 documents. Very quickly, if you work through the opinion, you'll find that you do in fact come up with the 80-odd documents that might be there at the end of the day. And you'll have an understanding that I think you won't have if you try to go at it from the beginning instead of the end, of why those documents are there, and how they interrelate to each other, how they fit together. Once you've gone through that process, drafting a closing agenda and then determining what sequence the steps should be done in, I suggest is an easy process. Another element of the planning function is to assign responsibility amongst the people working on a matter. Very, very frequently there'll be at least 2 law firms and perhaps many law firms involved in a transaction. If you sit down early on in the transaction and decide which lawyer should give what opinion about what matters, you've effectively designed a method of assigning responsibility for various aspects of the transaction amongst the various lawyers participating. Much more effectively, I think, than if you just sit down and try to think of the various things that have to be done in the transaction and say, well, you do this, and you do that, and you do that. If you do it that way, halfway through, you may find that assignment of tasks and assignment of responsibilities in the end of the day, really doesn't make a lot of sense. If you start backwards with the opinions, I think you can fit it together better. A good example of that is an international transaction where you have law firms from different countries involved and the interaction of different legal systems and jurisdictions, working out which law covers which part of the transaction and which lawyers should speak to various parts of the transaction. In those situations can be very complicated. And if you sit down at the beginning with the opinions and trying to decide who gives an opinion on what, some of the pieces, I think, will fall into place. For example, if you have a company in Ontario entering into a contract in New York governed by New York law, one of the concerns you'll have is the enforceability of that contract. Obviously, the two most likely jurisdictions where disputes could arise would be New York and Ontario. The ingredients that go into deciding on enforceability will be different depending on whether you try to enforce it in New York rather than in Ontario. If you enforce it in New York, you're going to want to know beforehand that the Ontario company will be bound by a judgment rendered by a New York court. That concern will lead you to seeking an opinion to that effect from the New York Council, and that will assign an area of responsibility to the New York Council and bring those points into focus in a way that perhaps they wouldn't otherwise if you weren't trying to pin them down with an opinion. Equally, if the dispute arose in Ontario, you would want to know that the Ontario court would apply the law of the contract, would apply New York law to the dispute. You would therefore ask the Ontario lawyer for an opinion that the Ontario court would in fact recognize the choice of law provision and apply New York law. And that will very effectively, I think, focus everyone's attention on what limitations there are to the Ontario court applying the New York law, and will raise for the clients involved in the transaction some additional matters that they should direct their mind to that I think they wouldn't have if you had not approached it in that way. Naturally, in a situation like that, when you're planning the opinions, not only are you using the opinions as a planning tool, but you should be very careful that the opinions you come up with interlock correctly. When you have different jurisdictions involved, you must be very, very certain that you haven't left a gap in the middle, that in fact the whole transaction is covered by the combination of opinions. Finally, the other aspect of the planning function is something I've already mentioned in connection with reporting, and that is to clarify the instructions from your client. Sitting down with the client and going through the assumptions that you'll have to put on your opinion, or the qualifications, or what has to be, putting it another way, what has to be done to give an opinion without those assumptions or qualifications is a very effective way of directing the client's mind to exactly what the client is asking you to do. For example, a full-blown financing opinion on a trust indenture that contains a fixed charge or a floating charge for a large corporation with a multitude of properties across the country. If you were to give a clean title opinion on those properties as part of saying that there's say a first fixed charge on those properties, you would, if you were to give a full-blown title opinion, you would have to, of course, search all those properties, which could be a monumental task. Sitting down with the client with the opinion and demonstrating to the client the kind of limitation that you would have to put on the opinion to give the opinion without doing those searches will focus the client's mind on exactly how long it would take to do the searches, how much it would cost, all that sort of thing, and allow the client to make an intelligent decision as to just how far the opinion should go. The final thing that I mentioned in my paper about functions is what I called the policing function, which is closely related to reporting, but comes in a variety of different ways. One method is one aspect of the policing function is the client policing the client's own lawyer, which is related to clarifying instructions, I guess. By having the lawyer set down exactly what has been done, exactly what assumptions are made, the client can effectively see what is being done, and the flip side of it is make sure that the lawyer does do some things that the client may be worried that he or she is not doing. If the client is sitting there and has the feeling that perhaps the lawyer is not really directing his mind to the matter, one way of increasing the formality, I guess, and forcing the lawyer to pay attention is to ask for a particular written opinion. The same kind of thing can be done by one lawyer to another lawyer. You've probably all had the experience of working on a transaction where you were concerned that some of the steps that you would have taken on the other side of the transaction are not being taken. One way of focusing attention on those steps and ensuring that the other lawyer does take those steps is to ask for a specific opinion. Hopefully, to give that opinion, the lawyer will go through the steps that you think are necessary to render it. And finally, an interesting aspect of the so-called policing function is a client policing its own personnel. In large financial institutions, for example, the institution may have a large number of loans officers all giving instructions to counsel to put loan transactions in place. All of those transactions cannot be reviewed by the senior personnel at the institution, and they will realize very early on that there's a significant danger of a loans officer going on a frolic and agreeing to things that perhaps should not be agreed to, and ending up putting transactions